Dr. Rich Edwards from Baylor University, and we're doing an introduction to the immigration topic. And as part of that introduction, let me have Nicole Cornish come right up here for a moment. How many of you in this room have at some point traveled to the National Topic Selection Meeting? Okay, 1, 2, 3, 4. Very good. Nicole came as a representative from the state of Texas last year, presented a topic paper. Her topic paper was on immigration. That was submitted to a national vote of 5 top topics that were selected by the Topic Selection Committee of the National Federation of High Schools. The top 2, which immigration was one of, went to a national vote. In that national vote, immigration won. So congratulations, Nicole. So if you have any questions about the topic, you can ask Nicole.
Yeah, I'm the one.
Thank you, Nicole. So before we get started in talking about affirmative cases on the topic, which is the main subject of our discussion today, we need to have a little bit of background on the topic. And yeah, Jonathan, you might be the person to help me here. Something I didn't notice that the screen was not. I need it. All right, we need something to prop. All right. All of this comes from a 1950s act, primarily modern immigration policy, the Immigration and Nationality Act, the INA. It's been amended a few times, most significantly 1986, IRCA, the Immigration Reform and Control Act, and then again in 1990 with what's commonly called IMACT, Immigration Act of 1990. Those are the most significant amendments. There have been a few others, but immigration policy is controlled by the INA. There are 4 major categories of legal immigration that are established in the Immigration and Nationality Act. Family reunification is far and away the largest of those. When we hear about family reunification now, as in over the last 2 weeks, we think about it in a different context. We're talking about reunifying children with families at the border. This is a different thing. This is talking about immigrants who are in the United States who would like to bring family members here to be able to be with them.
It's on the CD, right?
All of this is on the CD. You have a handout that's available that you can, log into. And by the way, I didn't display the slide that I showed you yesterday. Hopefully you've seen it in other sessions where you can log in online. Those of you who are interested in having this session recorded as part of your judge certification process, be sure to do that. Go online, and if you have a question about that, be sure to ask at the break, and I'll put that slide back up. But there's supposed to be a place online where you can also initial the back of your book afterward to verify that you've been here if you need that for judge certification. So the kind of family reunification we're talking about here is not reunifying children with parents at the border. We're talking about immigrants who are present in the United States and would like to bring family members here to be with them. That's the major part of U.S. immigration, legal immigration, and that's 710,000 per year that are allowed. Second major category, employment-based. That's mainly H-1B visas, but it includes a few other things as well. 145,000. Diversity visa program allows 50,000 immigrants. There are millions that apply every year online to be selected as a diversity immigrant to come to the United States. It's one of the main programs that President Trump lambasts regularly. And in every immigration bill that's been proposed in Congress recently, one of the elements of it is to eliminate the diversity visa program. If any immigration bill passes during the debate season, it will almost certainly eliminate the diversity visa program because it has very little support these days.
That's more commonly referred to as water.
Yes. though there are other lotteries, like the H-1B also has a lottery, but the one that most people mean when they say the lottery, or they'll usually say the diversity lottery, is that one. And then refugees, the average has been 160,000 over the last 3 years, but actually the amount is set by the president annually. President Trump has said he's going to limit it to 50,000. It's unclear what the actual number will end up being, but on the average, that's about 160,000. Once you get into this topic, and your debaters do, you're going to discover there are many, many visa categories, more than 90 of them. The most prominent ones that you're going to see debated are the H-1B visa. Did any of you debate the public forum topic that we had just a couple of months ago on the H-1B visa? I know we don't do a whole lot of public forum here in Texas, but that was a public forum topic just very recently. Also a reason why I think that'll be a major case on this topic. And the H-2A, that's for agricultural workers, guest workers, especially California farm grower people say that they can't get enough people to pick their crops and so on. Crops are rotting because they can't get enough immigrant farm laborers because of the restrictions in the H-2A visa program. So there will be affirmative cases proposing to increase that visa limit. The U and the T visas, you're going to hear a lot about this year because they deal with human trafficking and sex trafficking. So there'll be a lot of affirmative cases dealing with that. The U visa has a 10,000 limit every year. Right now, as you'll see with some evidence later, we have 120,000 backlogged waiting to get one of those 10,000 slots. People who have been human trafficked into the United States or victims of sex trafficking, and there are too few spots to cover them. So there will be affirmative cases dealing with that. The SIV visa program, there will be affirmative cases dealing with this. This is for translators in Iraq and Afghanistan and a few other places who have aided U.S. armed forces. A lot of controversy about especially the travel ban. The early versions of the travel ban were banning even SIV visa applicants, translators who helped U.S. forces, though the third travel ban made an exception for them, so the affirmative case is not quite as strong as it once was. That's the travel ban that the Supreme Court just approved yesterday, the third one. The F1 student visas. There are a lot of students who come to the United States on F1 visas. There's some pretty good topicality evidence saying those are non-immigrants. We'll talk about that when we get to the negative. EB-5 investor visas. You can basically buy your way into U.S. Green card if you invest over $500,000 and create a certain number of U.S. jobs in the process. You can get a green card as an immigrant. The TPS, temporary protected status. There are several categories of those, some from El Salvador, some from Haiti. President Trump has basically announced an end to all of them, though none of them have yet been kicked out. It's mired in the courts, and so there will be affirmative cases related to different categories of temporary protected status immigrants who are already in the United States but are in danger of being deported. And then the diversity lottery that we've talked about. Then, a major part of this topic, depending upon how well your debaters do on topicality arguments, will be undocumented immigrants. There are, by most counts, though we don't have an exact number, obviously, but by most counts, more than 11 million, 11.5 million by most estimates, undocumented immigrants in this country. Path to citizenship is very difficult now. The easy answer that people give is, well, why don't they just get in line like everybody else and become a legal immigrant? Act 90, the Immigration Act of 1990, made that very difficult. It essentially said if you are an undocumented immigrant in the United States who has been in this country for more than a year, you must leave for a period of at least 10 years before you can apply for legal entry into the United States. And how do you apply for legal entry into the United States? Well, one of two main ways. The diversity lottery, and good luck with that, because there are about 20 million people who register, and there are 50,000 that are granted. Or you can have a family member in the United States who applies for a family reunification visa if you have someone here who is a legal resident and can make that application. As you will discover in researching this topic, the wait time is now 20 years for a family reunification visa because the numbers are so overfilled. So when you say, why don't you just leave and get in line legally, you are really telling them, okay, first you got to leave for 10 years, and then if you're lucky, you can get someone to apply for a family reunification visa, the average wait time 20 years. You're probably going to be dead before you would be able to legally enter the United States, which is the reason there isn't a big run on undocumented immigrants leaving, saying, I'm going to apply legally. The DREAM Act will be a major part of this topic. The DREAM Act has been introduced in every session of Congress since 2001. It has never passed. It's come very close twice. It passed the House once and failed in the Senate. It passed the Senate once and then failed in the House. The DREAM Act would essentially provide legal status, a path to citizenship, for children who are brought to the United States under the age of 16 through no fault of their own and have completed high school in the United States but are in danger of deportation, can't go to college, or, you know, in many cases they do go to college, but they're in danger of deportation. So the DREAM Act would address that. President Obama, as you know, addressed it, getting frustrated with Congress not passing a DREAM Act, and so he wasn't actually legislative, it wasn't exactly an executive order, but it was something very close to that, a memorandum. He created DACA, the Deferred Action for Childhood Arrivals, which essentially said, we can't give you legal authority to stay because only Congress can do that, but you're not a priority for deportation. That's essentially what DACA said. As you know, President Trump announced an end to the DACA program, but DACA continues to exist because courts have essentially ruled that the president's ending of it is not legal. And so far, the Supreme Court has not ruled on that issue. And so Dreamers continue to be registered under the DACA program if they choose to do so. Courts have ordered that not only DACA continues to exist, but the U.S. State Department must continue to register students, people who entered the United States under the age of 16 in the DACA program. Unaccompanied alien children. This obviously is very much in the news recently, but in a slightly different way. In 2014, we had a huge number, in that year it was in the hundreds of thousands of unaccompanied alien children coming from Central America to the United States, mostly young teens or middle teens. And that number has gone down very significantly, and it's very low by any historic comparison right now. But it's obviously major in the news, and the United States federal government essentially agreed in the settlement for Flores versus Reno that children can't be detained for more than 20 days. And so you're going to read a lot about that in the news, especially with President Trump announcing that essentially he's ignoring that court ruling, and it will be interesting to see how that plays out. All right, so let's talk about affirmative case possibilities. The wording of the topic: the United States federal government should substantially reduce its restrictions on legal immigration to the United States. And could I get somebody to help me with time? I didn't wear my Apple Watch today. We're supposed to be done when in this session?
10:15.
10:15. Can one of you give me a warning at like 10? Okay. So I think the most common case is probably going to be bring more H-1B skilled worker visa holders to the United States. The limit right now is 65,000 plus 20,000. 20,000 includes graduates of U.S. institutions of higher education in STEM areas. So it's really 85,000 altogether. though most commonly you'll read that it's a 65,000 limit, but there is that 20,000 plus. But for years, US tech companies have lobbied Congress to increase that number. And often they've succeeded. In some years, back in 2011, in that era, it was like up in the 160,000. But right now it's back down to its originally authorized number, which is 65,000 plus 20,000. And US technology companies continue to say they can't get the computer skilled STEM workers that they need in order to maintain US leadership in the world. And so the various versions of this case that you'll hear will very often feature huge harm areas, like nanotechnology or cybersecurity, saying that we're failing in those areas, and we could all, go down because of the lack of cybersecurity or nanotechnology. There's one book even that ties H-1B visas to nanotechnology development, which the author of that book says can actually cure global warming, because nanotechnology could actually remove carbon dioxide from the atmosphere. So there will be affirmative cases that will claim huge advantages from increasing the H-1B visa quota. Syrian refugees, did I skip one or is that the next one? Yeah. Syrian refugees, President Obama promised to participate in the international program sponsored by the United Nations to allow Syrian refugees to enter. Though President Obama didn't promise a huge number, it was like in the 10,000 category, it was viewed as important for establishing US leadership and cooperation with the UN resettlement program. Obviously, the hundreds of thousands, even some claim millions, of Syrian refugees have gone to neighboring countries and very much to the European Union. But under President Trump, this program has essentially been ended, mainly because of the travel ban. That was actually a large part of its purpose. I saw an estimate the other day that there are about 12 Syrian refugees that have been resettled in the United States during the Trump era. So basically, we've shut down the entry of Syrian refugees. These are people who, have experienced incomprehensible ravages of war. The concern, and you will find evidence to this effect from the negative, that there is, of course, a danger that ISIS people fleeing from Syria will embed among the Syrian refugees, and that's the fear that President Trump raises. But there's awfully good evidence for the affirmative, and you'll hear it on this topic, that our best defense against terrorism are those who know its ravages and are fleeing from it. And among US refugee communities will be eyes and ears. And there's some awfully good evidence indicating that our best defense against terrorism is to allow well-vetted, and the vetting process, even under the Obama administration for Syrian refugees, is very stringent. Open borders. On this topic, there's an incredibly broad stream of literature, dozens and dozens of books in the last 3 years that I've seen, that argue that border violence is one of the great problems of our age, and the United States in its first 100 years had open borders. We had no restrictions on immigration in our first 100 years, and we seem to do fine with it. The European Union is often viewed as an example. You can go anywhere in the European Union without having to present, visas, that type of thing. So the argument is the United States should open its borders. That there could be a variety of harms that are suggested. Violence at the border is a major one. There are hundreds who die trying to enter the United States in the southern border, crossing the deserts. But also, world poverty. So many of these authors talk about the single most important thing that we could do to end world poverty is to allow freedom of movement. You might think that this is a crazy, ultra-liberal proposal. From some perspectives it is. But consider this. Among its advocates, the Cato Institute, the extremely conservative libertarian think tank that essentially says this is the best answer to corporate freedom, is allowing companies to get workers from wherever they can find them and allowing workers to go wherever jobs are needed. And that would be the control. The argument is if there are no jobs in the United States, people wouldn't come to the United States. And there's some historical evidence to document that. Even during the Obama administration, especially during the early years when we were just being impacted by the 2008 recession, the border flow had actually reversed. There were actually people leaving the United States among Hispanics rather than coming in. And why? Because there were no jobs in the United States. So the argument, both of those out on the liberal end and on the very conservative end, the libertarian end, is let labor do it, find its natural level. And if you allow that, then, I mean, there are pieces of evidence saying there are trillions and trillions of dollars available if we didn't have border restrictions. Right to counsel. And your first reaction to this case is one of our Baylor Briefs cases. People facing deportation have technically a right to counsel under the INA. It says that they have a right to be represented by an attorney, but they don't have a right that a criminal defendant would have to have a government-appointed attorney if they can't afford one, which almost no deportees can afford an attorney. And so they face an experienced government prosecutor when they can barely speak English or maybe not at all. If you read about these hearing processes, especially over the last few days, but it's been going on for a while, there are trials where literally dozens, sometimes 70 or 80 defendants are present in court, often only on video, and the decision is just made as a group. They aren't even given an opportunity to individually present their case. And the judge rules for 70 or 80 at the same time for deportation. And so many advocates of due process under the 14th Amendment, which the Supreme Court has long held applies not only to U.S. citizens, but to any resident of the United States, anyone present in the United States, including undocumented immigrants. They have a right to due process. Obviously, very much in the news over the last few days with President Trump announcing that people should be deported without courts, without judges. Remember that comment from, what, 3 days ago? Many people saying that's unconstitutional, and there's a pretty good case that it is. So this affirmative case would provide right to counsel at government expense. And why would that be topical, you would ask? And the reason is because of a lot of evidence like this. People who have a lawyer are at least 10 times as likely to obtain legal status as people who do not. And so the affirmative team will present the absence of a lawyer, the absence of a right to a lawyer as a restriction on legal immigration. If they had a lawyer, they would be 10 times more likely to obtain legal status. A little explanation is necessary there. The United States has long settled law and practice that says, that follows the United Nations Declaration, that a person seeking asylum that can present evidence that they are fleeing well-considered risk of persecution in the country that they left can legally seek asylum in the United States, which is one of the categories of legal immigration. And essentially the Trump administration now is saying, we're not even going to hear you. We're not even going to give you the right to be heard to present your case that you are being persecuted in your country of origin. Another affirmative case, this is one we have in the Baylor Briefs, the aging U.S. workforce. The baby boomers are retiring. and there are many who are saying this is creating a severe shortage in the American workforce. You probably noticed that unemployment levels are at historic lows, are hovering around 3%, which, that's already into the level where employers are having difficulty finding workers. And so this argument is the United States needs more immigration in order to satisfy the need for workers. And this is an example of a major report claiming that we need increased legal immigration, especially skilled workers, to meet the needs of the U.S. workforce. It's a little different from the H-1B visa case. It essentially says that we should, increase quotas, or some even advocate eliminate quotas for legal immigrants, just have proper vetting practices to meet the needs of U.S. workers. U.S. companies. Human trafficking, not hard to prove that it's a major problem, even in the United States. Doesn't just include sex trafficking, though that's a major part of it, but it also includes, as a matter of fact, here in Waco, about a month ago, we had, what was the name of the place? The Vegas, what was it? No, not in Las Vegas, it was in Waco, the Vegas Buffet something. Yeah, and they were raided by ICE, and it turned out that they had people who were basically working as slaves there, that were being human trafficked, and were everyday lives were being extremely controlled by the traffickers, and they were, I don't know the number of them, but it was in the dozen category, working in this buffet, which has now been shut down. But human trafficking, not just for sex trafficking, but for, labor purposes, is a major problem in the United States. And the major mechanism that we have to deal with that is the U and T visa. The T visa, many people complain, is too complicated, too restrictive. So the U visa is the one that you'll hear the most about, but that has a limit of 10,000. That's way oversubscribed. So, as that piece of evidence says, there are over 120,000 people who qualify for the U visa, but who cannot get one because there's only a $10,000 per year cap. All right, let's take a break for a few minutes and we'll draw a few names. When we get done with the affirmative, we'll start with the negative in this session, because the negative thing is longer because we need to talk about topicality. So, travel ban. You probably read this morning's paper. Justices uphold travel ban in 5-4 decision. This is the third travel ban. And as you probably know, appeals court, several lower federal courts had struck down even the third travel ban, as with first and second. Supreme Court has now ended that by upholding the third travel ban. So there will certainly be affirmative cases saying it shouldn't be so, that this violates the INA's restriction against immigration restriction based on nationality or religion. In the lower courts, the ruling was hearkening back to President Trump's promise during the campaign to initiate. Donald J. Trump calls for a complete ban on Muslim entry into the United States. And that language was enough to convince a number of lower courts, but not the Supreme Court, though we have 4 scathing dissenting decisions from especially Justice Sotomayor and others condemning the decision. And in the majority, they say we make no decision about the wisdom of the travel ban. We're simply declaring that the president has the authority to issue it. So there will certainly be affirmative cases overturning that. And in this case, the affirmative case would have to, the affirmative case in this area would have to be overturning a Supreme Court decision, which, those of you who haven't debated before or haven't coached CX before. The wording of any recent resolution that we've had starts with the United States federal government. What are the three branches of the U.S. federal government? Yeah. Judicial is one of them. The Supreme Court is the major arm of the federal government. So the affirmative team has what we call the fiat power to, if it chooses, call for overturning a Supreme Court decision. On most topics, we have some affirmative cases that do that, and you would have to do that on this one. There will be affirmative cases that will do comprehensive immigration reform. We've had many, well, we have bills like this in Congress all the time. And by the way, one of the handouts that I've given you on the CD lists well, I didn't list hundreds. There are 300 bills in Congress proposing change, in the current Congress, this one that we have right now, proposing changes to U.S. immigration policy. About 200 or so of them would make U.S. immigration policy more restrictive, which would obviously not be topical. But about 100 of them, and those are the 100-ish that I've listed for you in a document, it's a Word document in that CD, bills in Congress proposing to ease restrictions on legal immigration. And there are many of these. Really, every one of the cases that I'm talking to you about, there are bills in Congress proposing it. Why is that helpful? Because if you have your students go to congress.gov and you just put in a search for immigration and you find any immigration bill basically that's been sponsored by a Democrat, it's probably going to be topical. The Congressional Research Service at congress.gov provides a quick little brief summary of what that bill would do. Even those summaries are a little long for an affirmative plan in a round of debate. But those summaries give you very, very good ideas for how you can structure your affirmative plan. And in some cases, just taking a sentence or two from that bill would be the kind of thing that we normally do when we present an affirmative plan in the first affirmative speech. So it's a very useful resource for your debaters. Obviously, your debaters, some of them will find creative things that haven't been proposed in Congress, and that's fine. Don't have to choose from that list of things that are actually in Congress. But my point is, because this is such an incredibly timely topic, thank you, Nicole, there are many, many bills, even in the current Congress, proposing to do what affirmative teams will propose to do on this topic, meaning it's very real world. It's very much the kinds of things that our members of Congress have in front of them. So, pathway to citizenship. Providing an alternative to what we have now, which is you got to leave the country for 10 years, then you can apply. Comprehensive immigration reform would do much like IRCA did in 1986. Provide a recognition that if you've been in the country for a prolonged period of time, it's really not in the national interest to kick you out. You're embedded into communities. Very, very good evidence that it benefits our economy. Crime rate is, on average, much lower in predominantly immigrant communities, despite what President Trump repeats so many times. And so it's pretty easy to make the case for comprehensive immigration reform. That's what this affirmative case would do. Protecting dreamers. There will be affirmative teams that will propose passing the DREAM Act. Something's come very close to happening in Congress. There are numerous bills in the current session of Congress that would enact a version of the DREAM Act that would essentially protect from deportation those young people who are brought to the United States under the age of 16. So essentially through no fault of their own. They've been here for many years. They've gone to high school here. And it would protect them from deportation. Sanctuary cities. Our Justice Department has issued an effort to cut criminal justice funding for the more than 100 U.S. cities that have sanctuary policies. The term sanctuary city is very much misunderstood in this country. Supporters of the Trump administration characterize sanctuary city as a city that protects immigrants from deportation, that shields them from federal immigration authorities. No sanctuary policies do that. What sanctuary policies do is they say our local law enforcement will not be tasked with enforcing federal regulation on immigration. It doesn't protect ICE from doing its work. You know, a sanctuary city does not attempt to say the federal government dare not enter here to, you know, do whatever ICE wants to do. It simply says we will not instruct our law enforcement officials to carry out federal immigration law. If you want to do it, fine. That's what you've got ICE for, Immigration and Customs Enforcement. Let them do it. So far, the courts have blocked this effort to eliminate funding for sanctuary cities. But again, there will be affirmative cases saying there should not be such a federal effort. Interestingly, it will bring the federalism argument back into the immigration topic through a strange route, arguing that states and localities should have the right to determine what their own law enforcement that they pay for, their own city jails and whatever that they pay for, they should have the right to determine how those should be used, how those resources should be used, rather than being told by the federal government, you will enforce federal law. International adoption. There are two cases here that are interesting. In the Baylor briefs we have as our other thoughts case, I think we put it in there, I'm trying to remember, an adoption case which finds a really little loophole in federal law as it relates to international adoption. Congress passed legislation that provides automatic citizenship for people who are adopted, children who are adopted by U.S. families legally, gives them automatic citizenship. What it did not do, and actually when Congress passed that, the sponsors of it essentially said they would go back and fill the loophole. What it did not do was to deal with, I forget the number, it's like 60,000, of international adoptees who were already here by that time and had not been given citizenship as a result of that ruling, which only applied to future ones. So there will be a little affirmative case that will say, that's wrong. International adoptees, children who were adopted by U.S. families as children, should have citizenship. The more common adoption case is probably going to be this one. You will find on the web a pretty big literature saying the United States federal government is unreasonably restrictive on international adoption agencies now. This particular article that I'm citing here, if you read the whole article, here's the essential gist of it. It says, oh, well, during the Obama administration, it was not that strange that there was this crackdown on international adoption agencies, but we sure thought that President Trump would correct it. Instead, he's doubled down and essentially maintained the restrictions on international adoption agencies. So there are orphans all around the world who need a family. There are U.S. families that want to adopt, and yet all of these restrictions apply in international adoption agencies that should be eliminated. So there will be affirmative cases arguing that international adoption would be the route to increasing legal immigration in the United States. Immigrant detention. So very much in the news right now. Congress has this weird thing that's actually called a bed quota. You'll see in the literature is a bed quota. Essentially saying, I forget the number off the top of my head, it's either 45,000 or 35,000. I think it's 45,000. That it's actually interpreted by private detention companies as a promise from Congress as a result of them building their facility and constructing it and whatever, that the United States federal government will maintain at least, I think it's 45,000 beds that they will pay for detainees. From numerous human rights agencies, that bed quota is attacked as just a crazy restriction on due process that essentially says we don't care what your problem is, on any given night there have to be 45,000 detainees, immigrant detainees in U.S. private facilities in order to meet our contract. And so the way that it's often characterized, we don't care what your justification is, what your argument is, we need to arrest at least that many. It amounts to about 400,000 overall per year, I think is the number that I've seen. But on any given night, the bed quota is, I think, 45,000. And so you'll see in the literature a very broad attack on that bed quota. I've given you a number of publicly available PDFs and on the CD in the folder that's called Detention that attacks the so-called bed quota. Family reunification. Again, this is not the family reunification I'm talking about at the border right now. This is talking about the limit on family reunification visas. The argument is family reunification visas are an especially good thing because they increase assimilation in the United States. Families need a support system, and so family reunification is a good thing, and it's overly restricted now by the quota. We have so many family reunification visas that are now applied for that it so exceeds the quota that it's again like a 20-year wait time to get one of those slots, which almost, it creates the problem that you have to fill out all of this paperwork for a family reunification visa. Most of that detail is going to be out of date. In many cases, they would have already died by the time the visa comes up for actual doing anything with it. So the argument is we need to do something to get rid of that backlog. Guest workers, support of U.S. agriculture. One version of this argument is U.S. agriculture feeds the world. And if our crops are rotting, then the world is going to go hungry, not to mention increased prices in the U.S. So we need to get rid of the restrictions on guest worker programs, the visa limit. But in this case, it's not so much the numerical limit on the visa, it's all of the stipulations that go along with it, the restrictions that advocates say need to be relieved. And as that piece of evidence says, farmers are losing hundreds of thousands of dollars, crops are rotting, etc. Investor visas, I don't think this is a very strong case, but there are those who advocate it. The better argument right now is for restricting investor visas because so much fraud is connected to it. Mainly recently it's been in the news because of Jared Kushner going to China and essentially offering to a bunch of companies investor visas. Became controversial. So it's mainly been in the news for bad reasons lately, but there are those who say we need to increase the limit on investor visas. Temporary protected status, again, President Trump has ordered, though not right now, it's being delayed by court action, but has ordered the removal, the deportation of really all of the groups that are now in the United States. We have a large group in Haiti, from Haiti as a result of the earthquake. We have people who have fled violence in El Salvador. El Salvador is one of the most dangerous places in the world right now, and there are many people who are fleeing that violence. We have a large group of them in the United States. They're set to be deported if the courts allow it. Unaccompanied alien children, obviously this is the thing that's very much in the news right now. If you've been keeping up with this, President Trump recently issued another executive order saying the original thing of family separation is no longer valid. Now families will be reunited. The problem with that is, what do? Do you detain the family as a family, the parent and the child, if you reunify the family? If so, you fly in the face of the Flores Agreement, where the federal government faced a court challenge that ended up with the federal government agreeing to a settlement saying children can't be detained more than 20 days. So if children are detained with the family, does that mean the family can only be detained then for 20 days? If so, then we're back to the heavily criticized catch and release policy that the Trump administration accused the Obama administration of. So who knows how all of that is going to turn out. But unaccompanied alien children, a big thing in the literature right now, obviously. Spousal abuse. If you read into the law review articles dealing with this issue, you'll find a heavy criticism of what's called the Doctrine of Coverture. The Doctrine of Coverture in US law went away about 80 years ago. The Doctrine of Coverture essentially says the husband is legally responsible for the wife and, you know, has to do many, many things to under the law, whatever. But the Doctrine of Coverture lives on in immigration law and is very, very heavily criticized. What it means for holders of H-1 visa holders are spouses, almost all, well, predominantly female, because almost all H-1B visa holders are male. If you're a male coming to the United States, you can bring your family, so the wife comes on an H-1 visa, and there's a wide literature saying many women are being abused by their immigrant husbands. And because of the Doctrine of Coverture, they can't apply for relief. Only the husband can. What a strange thing that a woman essentially being abused has to have her husband abuser be the one to apply for relief because of the Doctrine of Coverture. So it's kind of an arcane legal thing to walk into, but you know, it's a way that affirmative cases will deal with domestic abuse, dealing with immigrant women. Special immigrant visas, SIV visas. There's a pretty big literature out there on the web lamenting the situation that translators and others in Iraq and Afghanistan primarily, who have helped U.S. service people, are now targets in their homeland and essentially are being targeted by the Taliban and whatever. And they need to have the protection of being able to come to the United States. And those have been very, very heavily affected by restrictions on, well, the various Trump travel bans. Though, you know, finally the third travel ban did make an exception for that, but the numbers are small that have been approved. And so there are many who argue, you know, we're giving a death sentence to people who have helped U.S. service people do what they need to do, especially in Iraq and Afghanistan. Diversity visa program, this is only an available affirmative case if during the season we have immigration legislation passed, which almost certainly will eliminate the diversity visa. There's almost no advocacy for increasing the 50,000, I haven't even read it, increasing the 50,000 limit on the diversity visa. The diversity visa program is heavily unpopular in Congress. Again, President Trump rails against it continually. Every recent bill that hasn't made it, but almost every one of them that I'm aware of, one of its provisions is to eliminate the diversity visa program. That may happen during the debate season. If it does, there are people who say that would be a bad thing. The diversity visa program is kind of viewed as the one last place where, you know, people can view the United States as, obviously the fact that 20 million people apply for this around the world, they still view the United States as kind of the beacon of something, the beacon of hope. And you lose that. You lose that feeling that, you know, the Statue of Liberty sort of thing. Give us your tired, you're poor, etc. Again, it's not much of an affirmative case unless it's eliminated. If it's eliminated, there are people who are standing up and saying, no, we should be doing that. Not much advocacy, I've seen none at all, for increasing the 50,000. All right, well, we have a few minutes, and let me stop and take about 5 minutes of questions if there are any on the affirmative. All right, so when you're negative, those of you who have debated, who have coached debate for a while in CX debate, you know that a winning negative strategy has to take the affirmative team off its game. If you just stay on their ground, if they want to talk about a travel ban, that's all you talk about, you're probably going to lose. They debate that every round. You need to take them off their game. And in traditional debate strategy, disadvantages are the way to do that. I'm going to suggest a few of them, but there are many others. And none of these disadvantages depend upon immigrant bashing. So brain drain is the first of them. The essential brain drain argument, and this applies to the H-1B visa thing, like, let's attract the world's best and brightest people to come to the United States. What happens when you do that? Well, you drain developing countries of the best and the brightest. And there's a very broad literature dealing with brain drain. It's a good two-sided debate, but actually most of the literature that's out there, and I've read everything that I could find on it, many whole books on it in the last couple of years, I prefer the negative to the affirmative on this. Yes, there are turns that are possible to it, but I would take this debate. Arguing that in the effort to build United States industry and whatever, we are draining the world's poorest countries of their best talent. And furthermore, as we'll get to it with the case, there are good answers to the case. You can turn the case impact, for one thing. This argument that, you know, we need the best and the brightest argues that big tech is what's going to save us all. As we'll get to it, if you want to, you can actually turn that case advantage. There's some pretty good arguments from people that you know. Stephen Hawking, who recently lost and whatever, who says artificial intelligence is going to be the end of us all. Elon Musk, not a big fan either. So that's available strategy. The other strategy that's available if you don't want to turn the impact is just to argue, you know, the US STEM workforce is being taken over by automation, by computers. The bigger risk may be the loss of jobs in that area because of automation, even in skilled positions. And that's a whole literature you can go into, which would not contradict this. Let the best and brightest stay where they are, helping developed countries. Population disadvantage. This is the best book on this, by the way. How many is too many? The progressive argument for reducing immigration to the United States. Nothing in that book is anti-immigrant at all. It's simply saying the US population is already at carrying capacity. That's a good thing. The biggest threat to that is dramatically expanding immigration. And he's saying, I know the easy answer to this is, okay, but you're serving as a safety valve for overpopulated countries elsewhere. So worldwide, it's actually a plus for the environment. He and many other advocates of this position answer that. They say the safety valve is a bad thing. What you do when you provide a safety valve is you allow other countries to not have to face the true implications of overpopulation. And that's a bad thing. So you'll hear this disadvantage a lot. The hegemony disadvantage. There are going to be many affirmative, you hear this on every topic, and it will be here on this one. Because there will be affirmative cases that will hand you the link to it. They will say that US leadership in the world is imperiled because we don't have the best and the brightest or, whatever. And they're going to restore US leadership by whatever they do in the affirmative plan. That's a link to the hegemony disadvantage. Hegemony bad essentially says US leadership is doing bad things into the world. Why? You can make this argument from either the extreme right or the extreme left, whichever one you want. If you want to go to the extreme right, the Cato Institute people, they say this is robbing us of our treasure. We can't afford to defend the world. We can't afford to be the world's policeman. It's going to impoverish us all. We need to bring the troops back home and stop worrying about being the world's policeman. From the far left, obviously the other argument that US leadership causes wars and etc. Horse trading. A disadvantage that's going to be new on this topic, but it's already big out there. And we've already talked about it. What it's going to be is, okay, you can reverse the travel ban and bring all of these Muslim immigrants to the United States. Are you sure you really want to do that? If you were a Syrian immigrant, would you want to be coming into the United States, into the Trump USA? And facing what it is you're going to be facing on the other end of that, with restrictions and deportations, and however you liberalize immigration policy, the Trump administration backlashing against it is going to use it as leverage for not just a balancing negative impact on immigration, but overbalancing. Deportations, building the wall, etc. Midterm elections, it's going to be big on this topic because there's so much evidence saying it's up for grabs right now. It's an open case, but most people say the Republican majority is going to go away in the midterms, but you do something that creates the motivation of the Trump base and no longer true. All right, let's talk about topicality a little bit. Here's the resolution. Those of you who are brand new to debate, and how many of you are there? Okay. Those of you who are brand new to debate know this. If you're negative, the easiest way to win, especially if you're debating an inexperienced team, is with a topicality argument. It so often happens that you make a topicality argument, or two or three of them, and an inexperienced negative team doesn't flow very well. They may answer one of them, but not three of them. And so you have two absolutely winning positions. It just happens in round after round of debate at a not very high level. It's almost impossible to lose by having a topicality argument turned around, as you could happen with a disadvantage, for example. So topicality becomes a unique threat to the affirmative. And you at least need to find out if they've got good answers to it. And there are a lot of good topicality arguments on this topic. The first is reduce. And this argument says reduce does not mean eliminate. Normal definition of reduce, to bring something to a lower or weaker state. Here's a court decision that says, taking the word in its ordinary meaning, reduce does not mean abolish. So you would use this against an affirmative case that's going to do open borders and say, you haven't just reduced restrictions on immigration, you've abolished them. And that's not topical. That's not what the resolution says. Or another approach to reduce. This argument would be, reduce means to make less. You don't make less, you give more rights. Your case doesn't reduce restrictions. Your case adds additional rights to immigrants. For example, the right to an attorney, or anything that increases immigrant rights. You'd argue the resolution gives you no power to do that. And your explanation that, well, if they had an attorney, more of them would be able to stay in this country. That's topicality by effects, the negative team would argue. Your explanation clearly establishes that you're justifying effects topicality. The clear language of your plan does not reduce a restriction, but it adds a right. Substantially. Those of you who have used our products for a few years, you know that our topicality casebook is written by Dr. Ryan Galloway from Stanford University, and one of his favorite arguments is this definition of substantially from Black's Law: without material qualification. So plans, as he would say, plans which condition the increase, well, that's still the education topic that I've got there that I didn't adequately revise. Sorry about that. But I'll guarantee you Dr. Galloway's argument stays the same way every year. You have in your plan a restrictive interpretation. It has qualifications. And the Black's Law definition of substantially is without material qualification. It's refers to the federal government's own. The state of Arizona has very restrictive legislation on immigration. SB 1070, I think it is, 1040, one of those. Alabama has restrictive legislation. We even have some in Texas. It's the reason that California state government officials said they can't travel to the state of Texas. We had that interesting thing when we had the National College Debate Tournament in Texas a couple of years ago. Georgia has a restrictive law. If you look at the topic paragraph that the wording committee and Nicole wrote, it suggests as a possible affirmative case overturning those state laws. But if you were debating such a case, you would say that violates its. Those are not restrictions of the United States federal government. Those are restrictions that state governments have imposed that you're overturning. Does the federal government have the right to overturn state law? Yes, by, numerous court rulings. The United States federal government has the power, but that's not topical because of the word its, the negative team will say. Legal. Legal refers to a particular subset of immigration. So cases reducing restrictions on undocumented immigrants are not topical. Legal immigration includes those four categories. When we come back from break, I'm going to run you quickly through the Word document that I've made available to you on the CD and also in the handout and highlight some of these arguments there. We've got a couple more topicality arguments to go through, but let me draw a few names and we will take a break. Did you get a CD with the handouts? Did you all get a CD with the handouts? Okay. All right, we're going to finish this whole thing on topicality, then I want to call your attention to one of the Word documents that's on your CD. So, immigration. There will be negative topicality arguments that will say immigration does not include non-immigrant visas. Most visas are non-immigrant. The standard definition of immigration is immigrants collectively. So the negative will argue a distinction has to be made between immigrants and non-immigrants. And so, for example, this piece of evidence, there are two main types of international migration, temporary and permanent. People in the first type, called non-immigrants, are by far the largest number, to include millions of temporary visitors, tourists, students, business travelers, and guest workers. The second group involves immigrants. These are people who seek permanent settlement in a new country. I'm going to show you a bunch of definitions that support that view in a little bit on the Word document. And then the word to. If you're negative, you're going to argue this resolution does not say reduce restrictions on legal immigration in the United States, but to the United States. So standard definition of to, toward a given state. And so negative will say the topical cases are ones that deal with people coming from outside into the United States, not the people who are already in the United States, such as dreamers, such as undocumented immigrants, such as temporary protected status people who are already in the United States. All right. Before I talk about that, I want to talk about one other thing. I want to show you that topicality document. Topicality is going to be so huge on this topic. It is on most topics, but it will be especially so on this topic. Probably need to have my computer up front to do this. See if I can mirror this. So are you seeing my computer screen out there?
Yes.
So you have this document on the CD, and also I made it available to you for digital download from the UIL site. This is the topic paragraph that went out with the ballot. That can have some significance on this topic because it's the best evidence that we have of the framers' intent. If you get into a debate and around about what the framers intended, this is the best evidence that we have because it was written by the topic author, by Nicole, and by the wording committee, approved by the wording committee of the National Federation Topic Selection Committee. And if the affirmative team says, well, it doesn't provide notice, this goes out on the topic ballot. So people who vote for the topic, this is what they're looking at. It specifically mentions things like the DREAM Act. It mentions amnesty for immigrants already living in the United States. All of that could be important if you're affirmative, especially if the reason for topicality is something like notice. That's often one of the reasons that negative teams will say topicality is a voting issue. We had no notice. Well, this provided quite a bit of notice. It was on the ballot. I've listed for you Dr. Galloway's 10 reasons for topicality arguments. And we've talked about many of them, but that's what this does. Then I've given you definitions of each of the terms in the topic, so lots of definitions of substantially. There are lots of ways that you'll find substantially contextually, and I've listed a bunch of those for you here. Definitions of the word reduce. We already talked about the definitions that say it can't mean the same as abolish. But if you're affirmative, notice these definitions. Reduce means to do away with something or to disband it. And by the way, if you're new to debate, if you're new to coaching debate, sometimes you can get overwhelmed with this feeling like, okay, somebody needs to get their act together. What does this really mean? Welcome to the world of definition. It's why we have lawyers. It's why in any field you have debates over words. It's what we do, and it's what debaters do. So, definitions of its, definitions of restrictions, definitions of legal, definitions of immigration. This is a wholly other topicality argument that Dr. Galloway suggests. Immigration means coming into another country, therefore not including people who are already here. And all of these definitions talk about coming from outside in. This is, if people say, well, you're defining immigrants, not immigration. This definition protects you if you're negative. Immigration, immigrants collectively. But then there are definitions like this one, if you're affirmative. Immigration includes the movement of temporary workers, refugees, and clandestine and unauthorized migrants, as well as permanent and legal immigrants. Immigrant does not include students or tourists, does not include investors. Most visa holders are not immigrants. This whole page gives you a list of non-immigrant visas from the book U.S. Immigration Made Easy. Almost all visas are called non-immigrant visas, and this is a list of all of them. Refugees are immigrants. Etymologically, the term migration means to move into another space. Thus, another possible negative topicality argument as to why immigration doesn't include people already in the United States. Legal immigrants are distinguished from those who are non-immigrants. several pieces of evidence, but then when you define legal immigration as a phrase, lo and behold, legal immigration includes non-immigrants. What a deal. Legal immigration consists of two major categories: permanent resident admissions, LPRs, and temporary admissions of people who must show that they do not intend to remain permanently, or non-immigrants. In addition, the law recognizes dozens of other categories of immigrants who are lawfully present under a variety of conditions. Legal immigration encompasses permanent immigrant admissions and temporary non-immigrant admissions. And several other pieces of evidence to say that. Definitions of two. In some ways that seems an open and shut topicality argument, but consider definitions like this. Two includes a situation where a destination point has already been reached. Topicality is a pretty debatable issue. For those of you who are new to coaching debate, the most important thing that you can emphasize to your affirmative team is have available definitions of every term in the topic. I don't care what argument the negative team is making, there are definitions of the word that they're using that go the other way. All right, back to our discussion.
I had a question about that.
Yep.
That was my thought at first. If they bring up the topicality and they bring up this definition, how does the affirmative go on with their argument?
Almost always the affirmative response should include a counter definition. Occasionally it happens that the negative team will offer a definition that doesn't support their argument, but that's the rare exception, and usually not a very good team. So you generally need to offer a counter definition. So if they've defined substantially as at least 20%, well, from that list of definitions of substantially, you can first find things saying substantially does not refer to a percentage. And second, there are definitions of substantially such as more than imaginary. I think our case is more than imaginary in the way that it does whatever. So there are answers to every one of those arguments. Thus the debate will go. Most topicality decisions are reached because for the negative, are reached because the affirmative team just doesn't answer or doesn't have a counter definition. There are counter definitions for every one of the major topicality arguments on this topic. So if you're affirmative, you don't need to lose to topicality. Usually you're going to lose because you didn't flow well or you didn't understand their argument. Make sure you ask in cross-examination if you're not sure what it is they're arguing. But most important thing, offer a counter definition of whatever term they're basing their topicality violation on. Some people look at this topic and just say it's so overwhelmingly affirmative, what can a negative team possibly do? We've already talked about topicality, there's that. But what I've tried to do is in every one of these strategies, I haven't gone to the anti-immigrant bias. And I still think there's a very viable negative position. So let's first of all let's increase the visa numbers for the H-1B visa. This really gets into a literature that many of you know from last year's topic on the education topic when we talk about, do we really have a need for more STEM workers in the United States? Because that's what the affirmative case is alleging. We've got to have more STEM workers, or we're not going to have cybersecurity, or we're not going to have nanotechnology, or we're not going to have big artificial intelligence. So one strategy, and it's not the one that I feature in this evidence, but a very easy strategy is to just argue that we don't have any shortage of H-1B or skilled workers in the United States. There's a pretty abundant evidence out there that Disney and other major companies have laid off their U.S. employees to hire H-1B visa holders. And why? Because they're cheaper. And because you have more control over them. They're in the country for only a period of 3 years. It can be extended for another 3 years. But basically, it's employer sponsored. If the employer decides to pull the sponsorship, they get deported. which gives a lot of power to employers over employees. So why do US tech companies argue that they need more H-1B visa holders? Because they can save money and because they have power over their workforce. And so you can use all of those arguments to take out the affirmative case. The other choice is to turn the impact. This argument that we need more big tech, we need more artificial intelligence, that if we just had, you know, the big computer H-1B skilled workers, and that's what a lot of these affirmative cases will claim. They claim big science, they claim big artificial intelligence, big nanotechnology. I haven't featured here the nanotechnology people who say that's going to run us amok. It's going to be used in defense technology. You know, it's going to, there are people who very, very much fear nanotechnology running amok. This is an example of, we don't need runaway artificial intelligence. It may kill us all. These are not crazy people. I mean, Stephen Hawking just passed away, but easily regarded as the world's leading physicist. Elon Musk is not just some crazy person. You know, he's the founder and owner of SpaceX. And there are many other big tech people who say we should fear this. Technology should not be just galloping. Let's keep it at a steady pace. And so all of the affirmative claims that we need to have this in order to get these big affirmative advantages, those big affirmative advantages can be impact turned. Syrian refugees. I promised a couple of you that if we have time left over, and this goes until 11:30 or 11:45? 45. I promised a couple of you that if we have time left over, we'll talk about counterplans. Here's a case you need to counterplan. I think. There is an outstanding article in the November-December issue of Foreign Affairs, and if you're familiar with that publication, it's major. I mean, this is not just some crackpot, Alexander Betts. And his major recommendation is we should be providing more funding for the placement of Syrian refugees in Jordan. His argument in that article is Jordan needs them, and the Syrian refugees would benefit from it. They would stay close to Syria. The Syrian civil war won't go on forever. They will be able to return more easily to their homeland. They will be in a culture that they're much more familiar with. And so this article just thoroughly argues this would be the best United States foreign policy, to increase aid for the resettlement of refugees in Jordan. Benefit both Jordan and the Syrian refugees. The case argument that you'd be making on this would be the same thing you'd be making on the reversal of the travel ban. Why do we want to bring Syrian refugees here in a Trump world? You're not arguing that Syrian refugees are, you can if you want, but you're not arguing Syrian refugees are dangerous. You're arguing it doesn't benefit them to bring them to this country, enlivening a backlash, making them the object of attack. They would be better off if we would support them near their country of origin. And so with this counterplan, it would be made competitive. We'll talk about competitiveness for those of you who are new. It would be made competitive by your disadvantages, your backlash disadvantage, especially. Your horse trading disadvantage especially. I would argue the superior policy is to increase funding for the resettlement of Syrian refugees near their country of origin.
Doctor, in my circuit, I travel a lot with my students, and I encounter topical versus non-topical counterplans, and there's so much. Everybody seems to have an opinion and a really strong one about it, and I've won cases on topical counterplans and lost cases on topical.
Right, and I'll talk about that briefly if we get to the counterplan, but let me say this. Most college debate theorists say counterplan does not have to be non-topical. Having said that, it's not even worth your breath to argue that. In high school, most high school judges, unless they're college kids or college coaches, are going to think that a counterclaim has to be not topical. You have to defend the non-resolution. And we've just gone through all the topicality arguments. It's so easy to argue that whatever counterclaim you come up with is not topical. You can just pick from all the reasons that we've just gone through. But this Syrian counterclaim, these people are not coming to the United States. By no definition would that be topical.
It's frustrating because the negative doesn't have the burden of topicality. But if we happen to run a topical counterclaim, then we're told, I voted against your counterclaim because it was a topical counterclaim.
A lot of high school judges will say a counterclaim has to be not topical, and their argument is the affirmative team is pre-assigned to defend the resolution. The negative team is assigned to defend the non-resolution. In this debate, we have two defenders of the resolution. So whichever one you buy, you should vote affirmative. That's the argument. Again, I could give you, I've summarized I've given you a PowerPoint talking about counterclaims where I summarized the college theoretical argument as to why it doesn't need to be topical. But again, why even worry about the argument? It's so easy to argue that your counterclaim is not topical. Why not just do it? Just place an argument, instead of dealing at all with the theory argument. We think it's okay to have a topical counterclaim. It's not necessary because it's so easy to argue. I don't care what counterclaim you pick. When you think about all the topicality arguments on this topic, it's so easy, just pick one to argue for not topical. In the case of the Syrian counterclaim or Jordanian counterclaim, they're not coming to the United States, so it's not topical by any standard. But that's an important thing to know about counterclaims. Open borders. The main affirmative argument, the big picture arguments that I see on these cases is solve world poverty. It's awfully easy on the case, without getting into anti-immigrant bias, to argue that this would not solve world poverty, but it would make it worse. Why would it do so? Well, there's a good amount of evidence saying only the well-to-do in other countries have the means to migrate. You know, even if you had open borders, nobody's going to pay you to migrate. You have to be a person of means to be able to migrate. So you're already taking the well-to-do out of developing countries to come to the United States. The poorest will stay. You will actually increase the problem of poverty in that country because you're taking out the best and the brightest. You're taking out the people of means, and you're leaving behind the real poor. And furthermore, you can make what, again, I wouldn't be quoting CIS to prove this, but you can quote George Borges, the Harvard economist, who makes the argument that immigration is a trade-off. He says its net effect is minor on the U.S. economy, but to the extent that it's negative, it does disadvantage the poorest among us because it increases competition for jobs. So you can add that argument if you want. The brain drain disadvantage also feeds this same argument. You're not helping world poverty by bringing more immigrants to the United States. Right to counsel. There are plenty of ways to go here without bashing immigrants or without saying, well, let's just deport them all. There is a surprising amount of evidence that you're going to find in this area that says we don't have very many well-trained immigration attorneys. It's not been an emphasis of U.S. law schools, and so there's an inadequate supply of properly trained immigration attorneys. And there's a lot of evidence like this one. Another startling finding is that having no attorney is consistently more beneficial than having a low-quality attorney. This finding has serious policy implications in regard to proposed reforms concerning representation for asylum seekers. You'll find evidence that asylum seekers that appear before a judge without counsel have about a 50% chance of having their asylum granted. Why? Because the judge kind of takes that into account. Whereas if you have poor counsel and they get poor advice and whatever, I mean, it's really surprising the quantity of evidence that's out there. There was an article in in the Wall Street Journal about this recently, talking about, it was a study actually, which says low quality representation in immigration hearings is actually worse than none. So you can take out that part of the case, but then you're left with all of the Trump backlash, you're left with all of the horse trading disadvantage, you're left, you know, with the midterms. There are plenty of disadvantaged positions you can run against this, and you can minimize the case very seriously by just these solvency arguments. You know, there aren't enough well-qualified immigration attorneys to go around. It's a hard way to go if you're negative. You're going to get it turned if you argue that this will cause deficit spending or, you know, deplete the budget, because there's good affirmative evidence on this case that it actually saves the government money to have attorney representation. So I wouldn't go there. Aging workforce. One of the Baylor briefs cases that we have, a lot of people make this argument that with the workforce aging, the retirement of the baby boomers, we need to have more immigration. All you need to do is get into all the literature about the number of jobs that we are going to be losing over the coming years to automation. And that's the balancing factor. So it's actually a good thing that we have the retirement of the baby boomers, because otherwise we have looming in front of us as automation kicks in and takes away jobs. We're not going to have the problem of job shortage. So according, you know, you'll find a lot of this kind of evidence. 47% of US jobs are going to go away because of automation. Again, you're not bashing immigrants, but you're taking out the case by saying there's no worker shortage because of automation. And again, you've got all of the disadvantages about horse trading and, you know, midterms and politics, etc. Human trafficking. Well, there's a pretty good literature here, and again, you're not getting into any of the Trump arguments one way or the other. But the U.S. program is, you'll find quite a bit of evidence in law reviews that the U.S. actually leads the world in its dealing with human trafficking. Do we solve the problem? Yes, we do. But we have pretty good ways of dealing with this. And here's what I would do if I'm negative. Most of the affirmative evidence deals with the U visa and the fact that the U visa has the 10,000 limit. The T visa is also available, and that limit has never been reached. If I were negative, I would defend the T visa program as the superior way of dealing with this. And there's a lot of evidence defending the T visa program. So this author, for example, in a law review says our T visa program is a model for the world in the protection of immigrants from deportation in human trafficking. Furthermore, even with the U visa, that evidence that says there are 120,000 waiting for a U visa, okay, well, those 120,000 are still in the United States. They're allowed to await receiving a U visa while they're on that waiting list. So they're not deported, they're still here. So 120,000 waiting for a visa sounds bad, except they're in the United States. Sure. Topicality on all of these. The travel ban, well, the slide that you have on your CD is different from the one that you see here because the Supreme Court just proved it. So you have to adjust a little bit your case position on this. But this was the the Washington Post editorial from this morning saying Trump has not been vindicated. And what that editorial says is it actually proves that court limits have worked, because it was not the first Trump travel ban that passed. That failed court muster. It was not the second one, but the third one that now included a bunch of loopholes and was a watered down version that passed. And their concluding sentence is the Trump policy was forced to change. Checks and balances did operate to that extent. So yes, it was a setback, but you know, the third travel ban was not the first travel ban. So still, court challenges were present and worked. Keep in mind all of that argument that we had on Syrian refugees. Most travel ban cases are really Syrian refugee cases in disguise. That's the big harm they're probably pointing to. And so you can counterplan that, just like you could counterplan this one. There are other ways to deal with Syrian refugees. And do we really want, if we overturn the Trump travel ban, do we really want this Muslim influx into a Trump United States right now? And so all of your disadvantages that talk about the backlash and the midterms, and this is obviously going to become a major Trump issue if you did that, would energize the Trump base, etc. This is an example, though, of your kids are going to have to keep up on this topic. I mean, things are going to change from day to day and week to week. So follow the news. Makes it a good topic. Pathway to citizenship. This is probably the hardest way to go when you're going to exclude from your use the anti-immigrant literature. But here's an interesting fact. That piece of evidence at the bottom. While campaigning, Mr. Trump had promised to round up and remove all 11 million undocumented immigrants estimated to be living in America. It was an impossible vow to keep, but the country still braced for the onslaught of deportations. Yet figures released by the Department of Homeland Security on December 5th show that the total number of deportations has declined over the past fiscal year from October 1st, 2016 to September 30th, 2017 to the lowest level since 2006. With all of the Trump rhetoric, really what's happened is he's got this big focus on the border and all of the attention to that. Deportations have not gone up, they've actually gone down. So you're not really defending Trump. You're essentially saying Trump has all of this rhetorical anti-immigrant thing, which is going to get the link to all of our disadvantages. But your case advantage of protecting people from deportation is not as big a deal as you're making it seem. It's probably less of an issue right now than it's been for a decade, according to that piece of evidence. There's been a lot of rhetorical hoopla, but really the Trump activism and action has been at the border, trying to close the border. It hasn't been focused on the issue of deportation despite all of his rhetoric. As a matter of fact, there are Trump supporters who are worried about the fact that he is hollowing out ICE in the inland by sending them all down to the border where they don't really need to be anyway. But that could be good if you are under threat of deportation. Protecting dreamers. Well, I think a negative way that you can go here is, first of all, the courts are protecting DACA. And, you know, the Supreme Court could overrule it tomorrow, so who knows. But there are actually people who predict that they won't. And the courts are ordering that new people need to be registered in DACA and so on. But the other way you can go is to argue that this sets up your horse trading disadvantage. In the Trump administration, do you really want to be going out and registering as an undocumented immigrant? Because that's what you got to do to preserve your DACA status. Because as quite a bit of literature indicates, dreamers recognize that by doing so, they're exposing their family to deportation. It might be best just to lay low. Let the courts protect you, but why do you want to go on, in the Trump administration, the Department of Justice records as, by the way, I'm an undocumented immigrant. Here's where my family is. A lot of dreamers, a lot of DACA people are worried not so much about themselves, but about their families, exposing their families to deportation because their families would not be protected. Sanctuary cities. There's an interesting argument you can make here. There's several law review articles that talk about what a wonderful thing it is that in the Trump administration we have state attorneys general, mostly Democrat-controlled states, but some Republican as well, who are standing up against the Trump administration and essentially organizing legal opposition. And, you know, so you can make the argument that this is actually the best protection that we have against Trump administration excesses that we have this activism. And so to the extent that the affirmative, in a not very significant way, seems to solve this problem, and the activism goes away, the courts are protecting sanctuary cities anyway. But it's a good thing that we've had the legal activism, that we've got essentially people standing up, bringing court cases. And again, there's some pretty good evidence that state attorneys general is our best bulwark against the excesses of the Trump administration. International adoption, I'd rather be negative on this case than affirmative. A lot of the literature that you'll see online about why is the Trump administration continuing? It seemed to be anti-regulation. Why is it continuing its regulation of international adoption agencies? Well, because we had some very well publicized abuses where international adoption agencies were serving almost as human traffickers in bringing kids into this country and not carefully screening, not forcing the international adoption agencies to follow careful standards. And so you'll find quite a bit of evidence saying, as this evidence does, intercountry adoption is often hampered by illicit activities such as human trafficking, exploitation of children. The increased demand of children from developing countries has at times turned intercountry adoption into a cover for illicit movement of vulnerable children. Thus, many vulnerable children became victims of child laundering, where they're legally separated from their birth families, processed through adoption agencies as orphans. And that's why we have the careful regulation that survived even in the Trump administration of international adoption agencies. So you're arguing that regulation is a good thing, not a bad thing. And we should keep it. Immigrant detention. So cases dealing with immigrant detention are essentially arguing we need to be relying on the alternatives to that, such as ankle bracelets, such as intense supervision, etc. But there are opponents of those policies, like this author who says the problem with such so-called alternatives is that they only increase the scope of incarceration and become an addition to traditional forms instead of an alternative. So even though electronic monitoring was supposed to be a tool of decarceration, it became an accompanying tool of incarceration, in addition to prisons and jails. So now right now we have the limit of, well, we can't build as many detention centers as Trump wants. And so he's ordering military bases to set up tents and whatever. At least that serves as some limit on the number of people that you can detain. Whereas if you eliminate that limit and you just have these low-cost alternatives, now you're bringing many, many more people under government supervision, where cost is now no issue. Family reunification. It already is the dominant form of U.S. immigration policy. So an affirmative, it says we need more family reunification. It's mainly what we have now. So again, this would be subject to the big horse trading disadvantage. Trump is already attacking family reunification at its current levels, let alone, abandoning the quota or doubling the quota. So expansion of family reunification would come at the expense of other forms of immigration. Guest workers, pretty easy negative position on this. We don't need agricultural guest workers because, actually this was the net. If you remember on a topic, 3 or 4 years ago we had the national final debate in MSDA where the affirmative team was using an immigration guest worker case on whatever topic it was. And the main negative position, the one that won, was we don't need it because agriculture is being mechanized at such a rapid rate that we don't have that need. And agricultural guest workers, again, are abused. They work in, the reason you can't get U.S. workers to do it is because it's very oppressive work conditions for very low pay. And H-2A guest workers are so heavily controlled by an employer, it's no wonder that they want more of them. Its critics say, they actually use the term, that it's indentured servitude. Investor visas, it's pretty easy to attack this program. It's rife with abuse, lots of evidence about that. And why do we want to make green cards up to the highest bidder? You know, is that really a good thing that we should be selling them? Temporary protected status. Courts are already protecting these folks, numerous court rulings. And again, you linked all of the disadvantages about horse trading and midterms and so on. Unaccompanied alien children. You're just gonna have to see how this plays out. We have the Flores Ruling that's a lot of people are talking about that prevents the president from doing what he wants to do already. I guess we're going to have to find out if the courts are going to stand up and enforce that ruling, which says unaccompanied children can't be detained for more than 20 days. They have to be placed with relatives, or you have to do something with them. You can't detain them for more than 20 days, whether they're reunited with their family or not. We're right in the middle of how that's going to play out in terms of whether the president's going to obey court rulings or whether he's not. Spousal abuse, main negative position is not going to be, on this case, the TVs or the UVs, either one, but the Violence Against Women Act and its protections. And it was specifically designed for this, for the powerless immigrant woman, to provide protections for her from abuse. Special immigrant visas. The third Trump travel ban specifically abandoned the effort to block them, which the first and second travel ban had done. So most of the evidence that people have out there on this came from the Trump travel bans, and an exception has been made for them, so this problem has pretty much been dealt with. The diversity visa program, this won't even be an affirmative case unless we have immigration legislation in the current Congress, which if there is something that passes, it will almost certainly kill the diversity visa program. But again, there's a lot of criticism of the diversity visa program, even from non-Trump circles, arguing this is a crazy way to run an immigration program where you select people at random. All right, we have a few minutes, and yes.